Today I'll discuss a landmark decision by the United States Supreme Court, Katz versus United States. It was decided in 1967 and became the core of the modern Fourth Amendment search doctrine. So let's talk about it right after this.
Number 35, Charles Katz, Petitioner versus United States.
The petitioner in Katz versus United States got indicted on 8 counts here in the Southern District of California, where I practice in San Diego, for wagering over the telephone. He was essentially sending bets between Los Angeles, here in San Diego, Boston, and Miami, in violation of federal law. In order to understand how Mr. Katz was caught, we need to place ourselves in 1960s. He was in a phone booth, and the agents placed a listening device to that phone booth.
But the facts are as follows. Mr. Katz was surveilled by agents of the Federal Bureau of Investigation for a period of approximately 6 days. During that period of time, the surveillance was conducted by the use of a microphone being taped on top of a public telephone booth.
Of course, many of you are now asking, what the hell is a phone booth? Basically, before the cell phones, people used public telephones. There were telephones on the street. You put a couple of quarters in and you make a call. And there was a booth, usually made out of plastic, metal, glass. In this particular case, it was a glass booth. So you would come in, you would close the door behind yourself, and you make a call.
What I could do to you, because you was faithful, and I didn't want to. But that's not your problem. You didn't know. Get off the phone. Get off the phone.
I'm sorry, Miss Andre, you were saying?
In this case, the agent placed a listening device on the outside of that booth. Prior to Katz, most of our Supreme Court cases dealt with the trespass idea to the Fourth Amendment, meaning that they always thought about Fourth Amendment in terms of, did the officers go into somebody else's property or trespass? Thus, it would be a violation. In this case, we're dealing with public property. This is a public phone booth. And Katz was the first case to really deal with Fourth Amendment protection when it dealt with public property, which made a whole lot of change in terms of the Fourth Amendment. While the petitioner and the government were arguing if the Fourth Amendment protects you in a public booth, the Supreme Court, for the first time ever, tells us in Katz that the Fourth Amendment protects people, not places, meaning that we have to focus on whether the person thought that whatever he was talking about was going to remain private.
Yes. I believe the following factors at least should be included in an analysis of this problem. One, what is the physical location? In other words, where did the conversation take place? Was it in a situation where numerous persons were present, or were there just a few people present? I think that bears on the issue. I think the tone of voice bears on the issue. I think that you can have a communication, for example, in your house, which almost everyone would concede, all things being equal, would be confidential. However, if you use a loud enough voice, I think you destroy your aura of confidentiality.
You have the windows open.
Absolutely.
The government argues that the petitioner was still visible to the government's agents when he entered the public phone booth. But the Supreme Court does not buy this argument. After all, the petitioner was not trying to exclude an intruding eye. Instead, he was trying to exclude an uninvited ear. With Katz, the Supreme Court shifted away from the notion that the Fourth Amendment can only be violated when there is a physical trespass. We now know that the Fourth Amendment can be violated when the person has an expectation of privacy into a tangible object, but as well as statements that are recorded by telephone or otherwise. So with Katz, we now deal with expectation of privacy.
Well, Mr. Martin, what did you seize in this fellow? You say this was a reasonable search of a what? Well, what I would say that is under this court's opinion in Berger, I think the words were seized.
So the words were seized, and the admissibility of that evidence, those conversations, depends upon the reasonableness of that search. And one of the rules about reasonableness of searches under Rule 41 is you can't search for mere evidence. Now, do you think these words over the telephone was a fruit or an instrumentality?
Certainly, I think in this case they were the actual means and instrumentalities of the crime. The crime is to transport wagering information or wagers over the interstate facilities, the telephone facilities.
Well, why didn't you go get a warrant then? So I don't see why you need a statute or anything else to make a search of a telephone booth like this.
I hope to make more videos about more cases that came later on dealing with expectation of privacy. And if you enjoyed this video, click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.